Hello, my name is David Carter. I'm an attorney at Gould Cooksey Fennell in Vero Beach, and I head up the firm's personal injury department. Today I want to talk to you about a recent tort reform bill that was passed by the Florida legislature and signed into law on March 24, 2023, called House Bill 837. It had multiple provisions, called an omnibus bill, covering a wide variety of topics that could impact the cases of people who are injured either in auto accidents, negligent security cases, and other types of cases that might end up in court in the state of Florida. So I want to talk about the major provisions covered by that bill and how it may impact someone who has been in an accident. The most impactful provision in the statute as it relates to automobile accidents, for example, relates to a change in what's called the statute of limitations. This is a provision that deals with how long you have after an accident to bring a lawsuit. And if you don't bring a lawsuit timely, a case, no matter how good it is, could be barred forever. So in Florida, prior to this law being passed, the statute of limitations for an automobile accident was 4 years. The law changes that to 2 years. So how does that impact a potential case? Well, for the most part, an attorney that you hire is going to know about this law, and it may just increase the timeline or change the timeline for when the case has to be brought and the amount of time that an attorney might have to try to get the case settled before actually filing a lawsuit in the courthouse. And that goes from 4 years to 2 years. It also means, however, that in certain situations, a tendency that we've seen sometimes is for potential clients to really work as hard as they can with the insurance company to try to resolve their case before ever hiring an attorney. Well, the insurance company's time is on their side. It is not on the side of the victim who has been injured by the negligence of another. And waiting now, the insurance adjuster may not tell you that there are time limitations that have been compressed that will make your case impossible to bring after the passage of time. So it makes it all the more important to seek out the advice of an attorney who represents victims of accidents as soon as possible following a crash. Another impactful provision of House Bill 837 relates to a concept called comparative fault. Comparative fault means that a jury, considering a case, compares the fault between the defendant and the plaintiff. In the past, prior to the passage of House Bill 837, a plaintiff could recover some damages if the plaintiff was partially at fault for the crash. Take, for example, an automobile accident where a plaintiff is speeding, but the defendant runs a red light. In that case, a jury is asked to apportion the fault between those two drivers. And they may come out with the defendant being 50% at fault, the defendant being 30% at fault, 80% at fault, anywhere between 0 and 100. So if you assume in the past a jury were to award a plaintiff $100,000, but found that the plaintiff was 60% at fault for speeding, and the defendant was only 40% at fault. In that situation, the plaintiff would only be entitled to recover $40,000, the proportional share of the damages based on the percentage that was assigned. House Bill 837 changed that so that if a plaintiff is found to be more than half at fault, let's say 51% at fault for the crash, even though the defendant ran a red light and caused the crash, contributed to the cause of the crash, there would be no recovery available for the plaintiff. The recovery would be zero if the plaintiff was assigned more than 50% of the fault. There's another provision of House Bill 837 that applies only in the context of what is called negligent security cases. These are cases where a plaintiff is injured in sometimes a mall parking lot or a hotel, and the claim is brought against the owner of the facility for not ensuring that their environment is safe. Let's say there's a rape or a murder on a piece of property owned by a corporation, a hotel, a mall. Prior to the passage of 837, the case was exclusively between the plaintiff, who was injured, raped, killed, and the property owner. And House Bill 837 changed that and has allowed now for the perpetrator of the crime, the actual criminal, to be placed on the verdict form. And the criminal's conduct is compared against that of the property owner. Well, you might imagine how that changes things if the focus in the case can be about who is more at fault, the intentional tortfeasor or the property owner who didn't do what they were supposed to do to keep their property safe. It really will almost have the impact of eliminating, from a practical standpoint, many of those cases, because a natural inclination, if given permission to do so, as House Bill 837 has done, would be to assign most or all of the fault to the intentional tortfeasor. And one of the big concerns about House Bill 837 is that it may discourage property owners from undertaking reasonable security measures, because there may not be the same level of accountability to them in the event one of their patrons, customers, is injured by someone out to do them harm. The concept is that if the property owner does their job appropriately from the start, it prevents the opportunity for that tortfeasor, that criminal, to harm a customer. And if now, as has been enacted by House Bill 837, there's going to be a comparison between the intentional harm doer and the property owner, that there may be perceived to be no real consequences from a jury considering that case. The next provision I want to talk about is the concept of insurance bad faith and how House Bill 837 impacts and the ability to hold insurance companies accountable if they fail to settle cases when given the opportunity to. Prior to the passage of House Bill 837, insurance companies had a duty to settle cases in circumstances where they have the opportunity to do so, and they should, if they're acting fairly, accept an offer to settle a case within policy limits. While that's still the law, House Bill 837 changed certain aspects to really give the insurance company the ability to avoid that responsibility, or at least raise the bar for when they are going to be held responsible for that. The first part of that relates to timing. So prior to the passage of 837, if a plaintiff, through the plaintiff's attorney, gave an insurance company a settlement offer prior to ever filing a lawsuit, a settlement offer in a letter, and gave them 30 days in which to respond and settle the case, and the insurance company failed to do so, resulting in a case being brought, ultimately the insurance company could be held responsible for the full measure of damages, even if it far exceeded the amount of insurance available. Take, for example, if there were a $25,000 insurance policy, a liability policy. The plaintiff, through an attorney, gave a settlement offer and gave 30 days to the insurance company to tender or hand over the policy limits of $25,000. And the insurance company, for whatever reason, failed to do so. And a jury ultimately awarded $250,000 to that plaintiff. Through different mechanisms, there was a way to hold the insurance company responsible for the full $250,000 worth of damage. While that's still technically possible, this law changed the timing of that and added certain responsibilities that were not present before to the attorney handling the case. The first is the 30-day common law provision that allowed for a 30-day deadline has been extended now by statute to 90 days. So now the insurance company has a minimum of 90 days after the attorney for the plaintiff gives them actual notice of the claim and sufficient information to justify that the full policy limits should be tendered. That changed things now because we don't know exactly when that 90 days starts to run. What will be considered enough information to start the clock? The other provision that is important in this is it added a bad faith, comparative bad faith provision that allowed the insurance company to point out or bring in the conduct of either the claimant, the plaintiff, or the plaintiff's attorney as part of the settlement process. It's called almost a comparative bad faith. That didn't exist before. So the result of this will be much more focus on what was given, what wasn't given, and the ability for the insurance companies to focus the attention away from their responsibilities to that of the attorney representing the victim, such that they can reduce perhaps the $250,000 award that we talked about before. They can now point to the plaintiff's attorney's conduct and say, well, he or she didn't give us this or they didn't give us that, so you should reduce that $250,000 down by some amount. Of course, this is a brand new law. It will be years before most of this will make its way through the courts, but it is certain to have a significant impact on the ability to resolve these kinds of cases, the bad faith type cases. The last part of House Bill 837 that I think bears some discussion relates to what medical bills and medical damages can be both presented and recovered in a personal injury case. Prior to the passage of House Bill 837, the standard was simply a reasonable medical bill. And so a plaintiff who is presenting their case, or a lawyer on behalf of a plaintiff presenting a case to a jury, could present all of the medical bills, and the jury would be asked to decide, are those bills reasonable and are they related to the injury being claimed? That was the sole criteria. Under House Bill 837, both the recovery and presentation of medical bills changes significantly, particularly for plaintiffs who were receiving medical treatment by doctors under what's called a letter of protection. A letter of protection is a device by which a doctor agrees to treat a patient and not be paid until the case concludes. So doctors treating under that are taking a risk that they may never get paid, and if they do, it may be a year or 2 years down the road. But historically, they could charge a higher rate for those services than what they might get from health insurance or Medicare or Medicaid. House Bill 837 limits LOP recoveries now to reduce them very significantly, and depends on the type of case that it is. If a plaintiff or patient has health insurance, but they still treat on a letter of protection, the doctor can only recover what the health insurance would have paid. If they have Medicare, they can only recover slightly more than Medicare would have paid. So it will impact the ability of some doctors, or willingness of some doctors, to take on a patient who has been injured in a car crash but can't afford to pay for their treatment along the way, because the doctors may not want to take the risk of not being paid, and the best that they can ever do in the long run is still a very reduced recovery. Historically, most bills that are passed in the state of Florida have an effective date that applies to all causes of action that accrue after the passage of the bill. House Bill 837 was relatively unique in that the effective date was tied to lawsuits filed in court after the effective date. Therefore, they were able, in some cases, to reach back to accidents that occurred a year ago, 2 years ago, 3 years ago, and say that the new law, which is certainly less favorable to plaintiffs, that new law applies to an older case. There are certain aspects, however, of the statute that were tied to, for example, the renewal date of an insurance policy. So it's very complicated, can be somewhat confusing, depends on the type of case that you're bringing and what provision is involved, which makes it all the more important to consult with an attorney to see if there's a way, if you have a case involving a personal injury, to find a way to see if some of the negative impacts of that law can be avoided, even though the effective date states that applies to all lawsuits filed after March 24th, 2023. I hope this explanation of the impacts of House Bill 837 has been helpful. If you have any additional questions or need more information, call us or visit our website at asksomeoneyoutrust.com.